You just say hello really quick. Sure.
Hello.
Okay.
Do you need me too? There's your test.
We ready?
Mm-hmm.
Hello, everyone, and welcome to the first installment of the National Press Foundation's webinar on legal issues for journalists. I'm Linda Topping Streitfeld, the Director of Programs here at NPF. For those who don't know us, the National Press Foundation is a nonprofit based in Washington, D.C. Our mission is to improve the work of journalists around complex topics here in the U.S. and internationally. For today's webinar, a couple of notes. Each of you has been muted so that we make sure everyone will be able to hear our presenter. He'll make his presentation first, and then we will take questions which you can type into a chat window. You should see the chat window probably on the right side of your screen. Just type your question and hit send. Now, we'll get to as many questions as we can, and you should know that like most things we do at the National Press Foundation, everything here is on the record and it is being recorded. We hope that by tomorrow there should be a link to it from our website, which is www.nationalpress.org. So let's get started. We're happy to have with us today Kevin Goldberg, one of the nation's foremost experts on First Amendment issues. He's special counsel at Fletcher, and Hildreth, and also legal counsel to the American Society of News Editors. Kevin is currently the youngest member elected to the National Freedom of Information Hall of Fame. He was elected for his superlative service in the pursuit of open government. He speaks and writes broadly on First Amendment, copyright, and trademark issues, especially as they relate to newspaper and internet publishing. He also is a member of the Executive Committee of the Board of Directors of the National Press Foundation. Kevin, thank you for joining us today to talk about these very important but somewhat tricky issues.
Thank you. I'm glad to be here, and I'm looking forward to doing these three webinars over the course of the next 3 months. You may hear me say this again at some point in the future, but my job today is actually less to teach than to scare the living daylights out of every one of you that is listening and paying close attention. If I've done my job, if at some point, before you hit publish at some point in the future, you sort of quiver just a little and think things through and remember me running through your head. That's what I'm looking for, because things tend to move very fast nowadays. Things tend, not to always be correct. Doesn't mean you're always going to get in trouble, but you can certainly minimize your risk just by doing that last little checkup. And that's why a lot of what I'm going to do today is probably in a very methodical order. Things I try to give sort of a checklist of things you can do. So let's just get started. We're covering 3 topics today generally related to publishing of information that is damaging to people's reputations: defamation, false light, and invasion of privacy, somewhat often referred to as publication torts. One thing I'll also note at the beginning while we're on the screen with all my contact information is, in addition to asking questions now, any one of you should feel free to contact me through any of those methods if you have follow-up questions that come to you tomorrow, later, if you have a problem. By all means, I'll answer. So, starting with defamation, there are more or less, since the 1964 case that many of you are probably familiar with, New York Times versus Sullivan, 8 things that have to be proven in a case. 7 actually have to be proven by a plaintiff. I put it as 8, but one of them is sort of quasi-defending, quasi-plaintiff. But the great thing about New York Times versus Sullivan, amongst other things, is these are always the burden of the plaintiff to prove. And those are, very familiar to you as well. There must be a defamatory and false assertion of fact that is made about the person suing you, that is published with the requisite level of fault on the part of the writer, speaker, broadcaster, publisher, that causes damage, and here's the one that may or may not be required to be proven by the plaintiff, without any form of defense or privilege for the defendant. So let's jump right into some of these. Defamation. The defamatory element seems pretty clear to most people, at least the definition of what a defamatory statement might be. It's something that reflects poorly on someone's reputation, morality, and integrity. The better issue is sort of how someone might actually go about proving that, what you need to know. Well, there are 2 ways in which this occurs. You have what we call defamation per se in most states. Defamation is a very state-specific law, while the various states and courts of appeal, state courts and courts of appeal, tend to review defamation cases in a very similar fashion. there are some specific differences between the states. This is one of them. Defamation per se are things that on their face will meet this element. And you can see what they are on your screen. They generally relate to accusing someone of an actual crime or something involving fraud or bad business practices. On the other hand, you may have a situation where you have a defamatory statement per quote, and that's where you use something in context, and then you've got a situation where a jury has to say, yeah, we think that would harm the person's reputation. Now, as journalists, why is this important to you? Well, if you see something, if you're writing an article where an allegation is made that's, that is alleging someone of having committed a crime, you need to think very hard about getting your statement even more precisely correct. Don't play around with words in that situation. Make sure then that as we move into the falsity element, that you have really considered the statement you're making. Make sure it's correct, because there really is no leeway. There's no chance for you to come back and say, well, this is really what I meant, or it couldn't be taken this way. It is defamatory. And of course, you have to also know the person you're writing about. Here's another sort of little, practical tip. It's very important to know your subject as you're writing about them. Know what the strength of their reputation is and how it might be harmed. Also, of course, is a good time to remember some people are more litigious than others. So this is a good time to remind you, always get a good sense of who you're writing about. Not just what they've done, but who they are. Number 2 is the falsity element. As you can see, I've put up a chart showing the differing levels of falsity that must be proven by a plaintiff based on who they are or what the issue is. The most important thing, I think, however, that people need to understand is falsity is not a strict liability proposition. Like, here's a situation where the First Amendment, if it means anything, it means we have the right to be false every so often. So what you need to do is work on, I'm not giving you a free pass to not be precise again, especially, as I said, in those defamatory per se situations. But you do need to know you have a little leeway, okay? So what falsity means is you have to be materially and substantially false. One example I always give, as we're now moving into the next element on the screen, one example I'll leave you with in terms of falsity is, if I write a story that said someone killed 5 people, and in fact they only killed 3 people or 4 people, yes, it's wrong. But is it materially and substantially wrong in a way that affects their reputation? Well, no. That person still killed a hell of a lot of people, and people are going to look at them in a different way. That's what material and substantially false means. In terms of quotes, it means you can clean up a quote. I don't advocate that you do it. But if necessary to create a flow, if necessary in a tweet situation to get you under the 140 characters, it is possible to do that. I say you do it sparingly and in a very restrictive manner. But it's not going to mean that you automatically have created a falsehood by doing that. Number 3 is that you actually have to be asserting a fact. The distinction at law used to be statements of fact versus statements of opinion. And statements of opinion could not give rise to a defamation lawsuit. Only statements of fact could. Well, now the law really looks at whether you are asserting a fact. And there are certain questions you ask. Number 1, as you see on the screen, is the statement or implication at issue a factual assertion? The way to answer that sort of is, or ask that in a different way is, could it be proven true or false if all the relevant facts are known? What you need to look at, and this is where things like the context come into play. Something that's written on the front page in the New York Times is very different than something that's written on the opinion page of the New York Times, or the Huffington Post, or the National Enquirer. You have to look at what the context of the article is. What is the tone of the article? Is it intended to be factual in nature? Or is it intended to be an opinion statement of some kind? Now, don't get too caught up in the fact versus opinion. I'm using those words for somewhat ease of explanation. We all know that you, if you're doing your job right, are backing up opinions with facts. Therefore, it's not enough to say, in my opinion, I think this person is a mass murderer. In my opinion, this person is a criminal, because you are stating what is primarily a fact, or your view of the facts, and that's not going to sort of remove the liability from you in the end. If you are asserting a fact, you are asserting a fact, and you're putting yourself in a situation that you could be sued for defamation. All right, and finally, what is the public context of the statement? Is it intended to discuss public issues? That's something that might push this toward an assertion of fact situation. Let's look now at a recent controversy that was sort of here in D.C. and how this has played out. Many of you are familiar with the fact that the owner of the Washington Redskins, Daniel Snyder, had sued the Washington City paper, the local alternative news weekly, for defamation, based on an article written in November 2010 called The Cranky Fan's Guide to Daniel Snyder, which listed in sort of an A to Z format all of the things he's done wrong, both as a owner of the Redskins and as a businessman. 3 of the key statements at issue before he dropped this case were, that's the Dan Snyder who got caught forging names as a telemarketer with Snyder Communications. Mr. Snyder made a great view of the Potomac River for himself by going all Agent Orange on federally protected lands and cut down trees protected by the National Park Service. And number 3, that he was tossed off the Six Flags board. Well, in each instance, the city's paper's defense was actually something that kind of brings in both the assertion of fact and the falsity elements. Either the statement was not false or was so false that it clearly was not an assertion of fact. For instance, Daniel Snyder, the city paper argued that, yes, it's technically not false that Daniel Snyder was caught forging names as a telemarketer with Snyder Communications. But as the owner of that company, he had a hand in the company's doing, so technically it wasn't false to put the statement that way. Similarly with tossed off the Six Flags board, where Mr. Snyder alleged that he was simply not asked to rejoin the board, the city paper's defense was there's really no material difference. Either way, he was not allowed to be a member of that board. With regard to the assertion of fact issue, let's look at the middle statement. Mr. Snyder made a great view of the Potomac River for himself by going all Agent Orange on federally protected lands. Well, Daniel Snyder alleged that the city paper got this wrong because he did not use the chemical agent Agent Orange in taking down these trees. Well, of course, that's not what the city paper was implying. What they were saying was we used a term that was better known as, colloquially known as rhetorical hyperbole, something that could never be taken as false. It was just sort of a statement of, just a completely over-the-top statement to show our dissatisfaction with them. And of course, in the end, there was no defamation lawsuit in court. Mr. Snyder dropped his claims, and it all not so quietly went away. Now, moving on again very quickly to the identification element, it's important to know that for purposes of defamation, corporations are people too. They can sue you, as can any living person who is identified in a published work. Doesn't mean that you have to be identified by name. A picture could suffice. A description could suffice. As long as the person suing can say, that describes me, and that has harmed my reputation because it's false and has caused me damage, they can actually continue with their lawsuit. Little question up there. Ever wonder why so many criminals are identified by 3 names? I'm living proof of this example. I'm a living example of the answer to this question. Not because I'm a criminal, but because my name is Kevin Goldberg, and there's another attorney in Washington, D.C. who is named Kevin Goldberg. If somebody made an allegation, for instance, that one of us was engaged in malpractice and just said Kevin Goldberg, the Washington, D.C. based attorney, committed criminal level malpractice, well, either one of us, or at least the one that didn't do that, could sue. That's why it's very important in many of these situations, especially if it's a very common name or a name that could have other people, could refer to other people in the same profession and same area. It's very important that you be very precise with the names. And for the record, he and I have made an agreement that we use our middle names at all times whenever possible to identify ourselves. But it is the reason that you hear, it's not just sort of a coincidence that serial killers all use all 3 of their names: John Wayne Gacy, Lee Harvey Oswald. It's Mark David Chapman. It is because at the outset, people needed, publications needed to identify these people very precisely to not cause confusion. And again, indirect ID can occur, which are sufficient facts to allow a person to figure out who it is that you're allegedly defaming. I want to talk about the concept of group defamation very quickly. This is a situation where you make a statement about more than one person, but one person says, this particularly harms me, or because I am identified as a member of that group, you have defamed me. And generally the rule of thumb here is if you make a statement about a group of people that are 25 people or less, any one person might be able to sue you. Any one person could have reason to believe that the statement would harm their reputation. Larger groups, unless very specifically defined and each person is identified, would have a lot of trouble. Individuals within those groups would have a lot of trouble suing if the statement was made just about the group. Publication is very simple. Publication does not require mass media publication for purposes of defamation. It will in some of the other things we talk about going forward. But here it's simply a matter of you make a statement about somebody to a third person. The issue that you need to remember here is republishing someone else's false statement is akin to adopting that statement yourself. There are certain exceptions, and it may be that you don't add damage, but republishing a libelous statement is the same as making a libelous statement yourself. Some of the areas in which this is going to play out soon, for instance, will be the issue of liking, or more particularly, retweeting a libelous statement. We have seen defamation lawsuits already arising through things that have been tweeted. You know, you can harm someone's reputation in 140 characters or less. That's a given. What if you retweet that statement? Have you, in effect, also libeled that person, and are you in trouble? It should give you pause. It should make you want to think harder about whether you're going to retweet everything you see in front of you, the most inflammatory allegations. Again, there are a lot of issues involved. Is Twitter the type of medium that should be seen as always asserting fact? Has your simple retweet caused damages? Does one of the defenses we'll hopefully talk about later apply? But on its face, you need to have that in consideration. Think about what you're tweeting, but think about what you're retweeting as well. All right, fault is one of the more important elements, not just because it's probably your ace in the hole as a writer or a publisher, but because it's one of the more difficult to conceive of or to explain. In the fault element, the key is the key question is, who is the person that's suing you? If the person is what we call a public figure, they have to prove a higher standard before they can win a lawsuit against you, actual malice. If the person is a private figure on a matter of private concern, they only have to show that you were negligent. Actual malice is defined as knowledge that the statement you made was false, or that there was a reckless disregard for whether it was true or false. And of course, negligence is simply a failure to act with reasonable care. All right, and of course that favors the plaintiff, because really all they have to do is show sort of a code of ethics or some normal standard that would be inherent, some normal journalistic standard that was violated. Let's talk about what public figures and private figures are. Public figures and public officials, they have this higher standard because we want more debate about them and about their actions. We want to hold them to a higher level of scrutiny. And this is one major difference between U.S. law and most foreign law, where foreign law tends to protect their public figures. We open them up to more scrutiny. So a public official or a public figure has to understand that there will be more discussion about them, more scrutiny of their actions. Why? Because they have greater access to the media to defend themselves. You know, if I'm a sports star, Michael Jordan, that's Wayne Rooney. But if I'm Michael Jordan and I have an allegation made about me, it's not very hard for me or my publicist to find my way on to every media entity in the city and respond. And finally, many of these people have voluntarily exposed themselves to risk of injury. They have to take the bad with the good. They get plenty of benefits by having sway over society, by the money they command in salaries. So they have to understand they have to give something up in return. And frankly, in many instances, people go out of their way to curry favor and curry attention, as Britney Spears did here. And therefore, the natural reaction is we have the right to scrutinize them a little more. A private figure, as I said, someone like me, I shouldn't be subjected to scrutiny by everybody in the world. So therefore, I get a negligence standard, unless perhaps I inject myself into a controversy first, and then for the reasons I've said to you earlier, I may transform into what we call a limited purpose public figure, and therefore, I would have to win a lawsuit by showing that the writer had committed actual malice in their statements. Some examples of what it means to act with actual malice are absolutely failing to interview a person with an opposing viewpoint. This is the easiest piece of advice I can give you. If you make an allegation about a person, call them up. Get their side of the story. Call their publicist. Make the attempt. You may not get them. Make a concerted, honest attempt. And if it ends up that you have to write repeated calls, were met with no comment, or were not returned, so be it. But do this. Okay? Using a headline despite knowledge that readers might misinterpret it. If it's not, of course, headlines are supposed to be splashy. Headlines are supposed to, create a little innuendo and get people reading further. But if it can be shown that you put the headline up there and already knew that it was likely to be misinterpreted, such as a headline, an actual headline that said, Cato did it, referring to Cato Kalin, who was a peripheral figure in the O.J. Simpson murder trial, where the editors of that publication, when they were put on the stand, said, yeah, we did discuss the fact that people were likely to believe we meant that Cato Kalin was actually the murderer. That's bad. You entertained doubts. You knew that people were going to misinterpret that and still went ahead with it. That's an example of actual malice. Fabricating an interview and exaggerating facts. Clearly an example as well. But again, the Supreme Court has said that simply changing quotes is not necessarily actual malice. Changing quotes in meaning and knowing you were doing it, that can be. Finally, so that's the point of this last one. Finally, the last element that someone would have to prove against you is that you've actually damaged them. A defamation lawsuit, like all of these publication torts, exists less to punish and more to put people back in the situation they were in as if this whole sordid affair had never happened. So there has to be some kind of damage. Number one, the first type and the easiest type is compensatory damages. You write something bad about me, I lose my job, you're responsible for my salary, once we can make that direct connection. Okay? My wife divorces me, I have to give up the value of my house in the settlement, I can sue for that. Usually this has to be shown before I can show something like special damages. The correspondent pain or suffering that I feel, the shame that I feel. Because really, I kind of love my wife, and I would be very upset if you led to the breakdown of my marriage. Finally, there are certain situations in which even those damages aren't going to get the attention of a major media publication. It's not going to deter them or others from doing the same thing, in the future. In the cost-benefit of analysis of things, they're willing to take that risk. Well, punitive damages are meant to make sure that people don't wantonly take those risks. And you'll notice that back at the top of this top of this slide, I refer to correction or clarification statutes. That's because many of these, which exist in the majority of states in the country, many of these have rules that say things like, if the plaintiff does not request a clarification, they cannot get special or punitive damages. Or if you do give a clarification or correction or retraction of some kind, you cannot be sued for special or punitive damages. So I urge you to look at your own state laws, and that will probably guide your response if you're hit with a request to clarify your statements. What can I get out of this? Well, if I can, make a clarification, if I can make a correction and know that even if I'm still wrong, all I'm going to be sued for are compensatory damages, that should factor into your decision. This might be a good time, I think, to break for some questions on that first part before we move into some of the defenses we'll be talking about here.
Well, we're looking at what questions have been sent to us. Let me ask you this. In talking about clarifications and corrections, if you publish something online and then you discover that it's wrong and you simply go back and change the text without specially noting that it has been corrected, does that suffice?
Well, it's this is another area that is still sort of playing out in law, but and again, most states have not rewritten their statutes to get to that issue. But the general rule is that a correction must be of sufficient prominence to be realized as a correction. So if for one thing, if you're the Washington Post and you publish a story on page A1 and bury the correction on page D7, that's not good enough. I would say that if you're making a correction, you need to highlight it. I would say in an abundance of caution, you would probably need to have a place on your website where you highlight these on a regular basis. And yes, I would do a strike through and a correction to make it known that we put this, we were wrong, we want you to understand why and how. And it doesn't hurt to have an editor's note to show that, it was an honest mistake and this is why we got it wrong. Because the point of the correction and clarification statute in part as well, the purpose of making a correction is perhaps to show that you never acted with actual malice. Because that's the time when juries and judges are getting inside a reporter's head. I mean, you never want to get to the situation of a deposition or a trial. But if they do, and they have the ability to go into your editorial process, this is the type of thing that can get you off the hook.
Are there other differences that we should know about in terms of defamation law, depending on the medium, whether we're online or broadcasting or in print?
Well, I've made reference to a couple of them. The idea that context matters, and the context in which you view an online publication is different in which something in hard print is probably viewed. And oddly enough, it's almost a free pass. You've got this medium, you've got the internet where people view things as sort of having less authenticity, having less gravity, being a little more fast and loose, as they are with tabloids, even print tabloids like the Inquirer. And therefore, it perhaps gives them a license to continue to make things up in the long run. Another area would be damages. Is there truly damage if something is posted on a blog? Will people find themselves feeling as though they have to sue to get their rights back? Is it more important, or is it easier and should we be pushing people to make their own responses now that they have direct access to the media?
We have a question from Liz who asks, what if you use a reputable source such as a State Department or data center and their information is incorrect?
Well, that's important for two reasons, because it, one, allows me again to refer back to the concept of actual malice. I think that if you use a reputable source, one you trust, not an unnamed source that calls you out of the blue, that you've done no backgrounds, investigation on yourself. The first time you use a source, you should be, investigating the source as much as you're investigating the story, of course. That can be very helpful to you. But if it's someone you've used in the past and you've used reputably, that's a good thing. And that's something that if they get it wrong, the idea that you've acted correctly will be very helpful. I mean, if they're wrong, they're wrong. But that's what the fault element recognizes. It recognizes that sometimes you can do all the right things and still get it wrong. More importantly, it allows me to refer to one of the defenses we're going to talk about soon, which is the fair and accurate report privilege, where when you rely on government documents in particular and accurately quote them, you basically have a pure immunity from any legal issues.
Another question, Brittany wants to know the difference between writing a fact-based article and writing an opinion piece. If your opinion is, can your opinion be considered defamation?
Your opinion cannot be, but if the lead up and the facts underlying that opinion are wrong, just the fact that you've written "in my opinion" or you've written it in an opinion piece isn't going to help you. Okay, if you falsely state that I committed malpractice, all right? If you falsely state that I committed malpractice and you're asserting that as a fact, I did this, this, and this, that is still going to be a defamation, even though you may be writing it in opinion piece as to why someone shouldn't hire me or why the NPF should never have me back as a speaker. But if your opinion is simply that I'm a bad speaker, well, because I have been found to be liable for defamation or serious questions have been raised, then you're probably okay because you made an opinion about my fitness to do these speeches, but you haven't stated necessarily a fact. It does bring me to another interesting point where I said, the difference between, say, I have been found liable for malpractice or there are questions regarding whether I've committed malpractice. Legal issues, particularly legal terminology, are very important things to get right. If somebody has been charged with a crime, say they're charged with a crime. If someone is being investigated, say they're being investigated. If someone has been convicted, say they've been convicted. I was reviewing a story this morning, actually, where someone had been found by the Federal Communications Commission to have engaged in false statements. The story said they lied. That is really not a great distinction, a great way to describe it. Technically probably correct, but as I said, especially again when you're dealing with government officials or government documents, precision can make you 100% certain that you're on the right side of the law. So don't play around with terminology if you don't have to. And I don't think there's a reason that you'd have to. So let's move on to some of these defenses as well. Let's say, these are things that are sort of your ace in the hole and especially can get you out of court earlier rather than later, because right or wrong, you may still get sued. And you don't want to be in that position. But if you are, let's think about how you can get out quickly. Number one, the idea of a statute, let's go back. Three of them are actually, the first two are very simple. The statute of limitations means that it varies state to state, but you must be sued within a certain time after your statement is published. In the internet age, this becomes a little more difficult to define with precision. So some states actually say that it's not enough that, we don't count back to the day you hit publish, the day the article first appeared. It could be the date that the plaintiff first knew about the allegation. And that's when the clock starts ticking to say what is usually about a 3-year period before they can no longer sue. Number two is jurisdiction. The jurisdiction issue means simply that you can be sued in one of three places. It's only fair and it's only useful to the court system to have you be sued in one of three places. Number one, where you live. Number two, where you work. Or number three, in a place in which you have what we call minimum sufficient contacts. If you're a writer for a Washington, D.C. based publication who lives in Virginia, it does make sense that you probably would expect to be sued in Maryland. If you fly to California to do a story out there, it might make sense to expect that you'd be sued in California. But if you publish it on the internet, it's still not likely that you'd be sued anywhere in the country just because someone reads the article there. But so do keep that in mind. You're not, just by publishing something on the internet, opening yourself up to a lawsuit nationwide or even worldwide. You do have to have some kind of relationship to the venue in which you're being sued, and that can be very helpful. Because a defendant, the plaintiff wants to sue you where it's convenient to them, they may not come after you. They may not come cross country. And if you can get something kicked out of court on that very procedural reason, it's very helpful to you. Finally, Section 230 of the Communications Decency Act is something you might be familiar with. Before 1996, there was a weird distinction between publishers, who were responsible for content, and distributors who were more akin to sort of a library. A publisher was someone who actively took control in editing the content. They were considered sort of the equivalent to the author. They could be liable if they edited things, but defamatory statements still existed on their website. A distributor was more of a library, and they had immunity. A distributor would be someone who says, we're not going to even take the chance in editing and getting it wrong. Therefore, we're going to leave everything up on our website. We can't be held liable. Well, you see the problem with that. It discourages people from taking good actions. It discourages people from trying to take an active role in terms of what third parties are publishing on their website. Congress didn't want that. So it simply said no provider or user of an internet interactive computer service should be treated as the publisher or speaker of any information provided by information content provider. What that means is, if you have a website and someone defames somebody else in the comments of your website, you run a website and there's a discussion board and a flame war occurs and someone defames someone else. You, as the middleman, are not going to get sued. If you make the statement on your own board, you could be sued, but as a speaker, not the owner of the website. This has been applied in not just defamation cases, but false light, public disclosure of private facts, intentional infliction of emotional distress, negligent publication, which are things that give rise like harm to other people, but not obscenity or other criminal laws, and not copyright and trademark infringements, though copyright has a similar law we'll talk about in a month. There are certain ways, though, that even a website operator could find themselves in trouble. The three things you don't want to do. As I said, you don't want to post content to your own website that defames somebody because you aren't going to hide behind that Section 230 protection. You do not want to prompt the poster. You don't want to create a website where the sole purpose is simply to have people come and defame other people. And you don't want to make broken promises. The key case here involved Yahoo, where Yahoo, on repeated occasions, when faced with a request by a Yahoo user to take down damaging pictures of that user, said, yeah, we'll do it. Yeah, we'll do it. No problem. Yes, we've just forgotten about it, but we'll do it. And then they didn't. And when they were sued, they hid behind Section 230. The problem was the court realized they weren't a speaker. They weren't they weren't involved in speech here. They were simply breaking promises and not acting, and therefore the Section 230 defense applies. If you say you will do something with regard to content, even if you don't have an obligation to do anything, because Section 230 would protect you. If you say you will take something down, do take something down. The fair report privilege I actually have already talked to you about, so we can deal with this pretty quickly. If you are relying on an official government document, a transcript of a legislative or court hearing, a statement, a transcript of a legislative debate, an official government document of any kind, and you fairly and accurately quote it, you will not be sued for defamation. So again, quotations from these documents are especially important. Accuracy from these documents is especially important. And the privilege, again, applies as long as stories are fair and accurate. It doesn't necessarily apply when you're just taking a quote from a source. Again, there are some differences between how each of the states deal with this. But if you're dealing with a document and you get it right, even if that document is wrong, you have immunity. Finally, we'll talk about what is the neutral reporting privilege and something that may come into play with retweeting. Not something that exists in every state, but something I like personally because I find it kind of interesting. If allowed, it applies in a very specific situation. A statement made about a public figure on a matter of public concern, the reporter is not investigating the story, doesn't have the ability to particularly determine whether it's true or false. They accurately report the dispute itself and its neutral coverage. Then you will be considered to not adopt the statement, but reporting it because the importance of the statement, or the newsworthiness of the statement stands on its own. For instance, if you had a dispute, I always like to use this example back during sort of when Kobe Bryant and Shaquille O'Neal were both playing for the Lakers. They were teammates and they didn't like each other. Shaq said some very mean things about Kobe at a particularly sensitive point in Kobe's life when he himself was charged with some criminal acts. All right, let's say Kobe Bryant 100% clearly, and he was acquitted of rape. Let's be 100% sure that he never raped anybody in Colorado. It's kind of hard to turn away from a story where one of his teammates would have been accusing him of doing that. The story is, the statement from his teammate is a story unto itself that has to be reported. If you do that fairly, accurately, neutrally, and it's clear that you don't believe the truth of the underlying statement, that's what the neutral reportage privilege is about. So let's take a breaking point here before we move into our last two topics, false light, the elements, and public disclosure of private facts.
Well, we have a question from someone who is based on the Mexican side of the U.S.-Mexico border. The laws, of course, are very different in Mexico. And the question is, do both laws apply to us? And I'm not certain which laws they're relating to.
Well, the laws that apply are the laws that exist wherever you're being sued. If you write something about somebody in the United States and you are sued in the United States, and that person can show that U.S. courts properly have jurisdiction over you, they're going to apply U.S. law in most instances. The concept of choice of law, what state's law applies, is the stuff of entire law school courses, certainly not the few minutes I have left here. But generally the rule is that the laws of the state in which you've been sued are the laws that apply.
Another participant asks a very important question for freelance journalists, and that is whether there are clauses or contract provisions that they should be aware of or that they should negotiate in order to reduce their vulnerability to defamation suits.
It's an excellent question. I don't know what you can do to reduce your vulnerability, but you definitely should be looking in your freelance contracts at things like indemnification clauses. Which may actually mean that you might have to, reimburse the publication you're writing for if you get it wrong, and may, as a result, get sued. The best you can hope for is sort of a situation where you might have a clause in the contract, and as someone who is usually on the other side of things, but has represented freelancers, I can speak to both sides of this. From the publication side, they want something that says, if you get it wrong, you pay our legal bills. Because we are definitely getting sued because we know the plaintiff knows we have the money. The deep pockets theory means that we're getting sued. People are getting sued all the way up to as high in the chain as it goes. From your perspective, you want something that says actually, very clearly, you're editing my material, therefore you're taking responsibility for it as well, and you're actually going to indemnify me. That's part of what I want. And they may say we're going to pay you a little less, perhaps, for that privilege. you may, depending on who you are, say that's okay. I'm willing, I'd like that protection. Anything in a contract situation is negotiable. That's the point of it. That's something to remember, and you can push back. How hard you want to is dependent on your individual situation, and and requires your knowledge of the situation. But anything is negotiable. So let's move on to wrapping up here with false light and public disclosure of private facts. False light is very similar to defamation, so we can deal with it quickly. There, you'll see some of the differences. It requires the widespread dissemination, not simply a reference to one other person, but the widespread dissemination of a highly offensive, not just false, but highly offensive false statement about the plaintiff, basically with the same actual malice standard. But what's the real difference? What's the real story with regard to false light? False light is primarily that situation involving broadcast or photography where something appears to be different than the reality. The best example I can give involves this picture. This was for a client of mine, and as far as I recall, the statute of limitations is run, so I'm free to use this without anybody getting in trouble. This appeared in their magazine, their monthly magazine. And I looked at the picture and I called up one of the staffers in response, who was in charge of publication, and I said, "That picture on page 7, where'd you get that?" I said, "Oh, it's clip art. We have the right to use it. There's no copyright issues." I said, "I'm not worried about copyright issues. I'm worried about whether the model who was who was used in that picture really thought the article about them would portray her as a high-class hooker, which is essentially what the story's about. That's false light. You have this picture used in a completely innocuous way, except that the story around it portrays things completely different. It happens in broadcast a lot. You ever wonder why, especially on stories like local broadcast stories involving obesity, you see people from the back and the bottom, so they can't be identified? Because to show them in a story that says we have an obesity problem in Washington, D.C., and show just a random taking your B-roll on the street out here on Connecticut Avenue, to show them and their face would imply that person is obese. That's false light. I mean, there was an actual case in D.C. which involved the local ABC affiliate where they were doing a story on sexually transmitted diseases. They went outside very close to here, doing some background photography on a video on the street, and happened to pan just across someone's face as the story was made. 1 out of 5 residents in the D.C. area has a sexually transmitted disease. You're eating your lunch, in DuPont Circle, when you're, completely unknowing that you're even going to show up there, and then you see yourself on the news that night, and the implication is you're that one person. That's false light. Let's move on to the last tier. The publication of private facts also involves the widespread publication about the plaintiff of a highly offensive type statement that is not of legitimate public concern. But here we're not talking about something that's false. Here we're talking about something that's very true. It just happens to be private, and it happens to be highly offensive. Okay, so if you have a false statement being alleged, you're talking about defamation or false light. If there's a true statement, you're worried about publication of private facts. How can you make sure that you don't find yourself in this situation? You have a fact in front of you. You want to know whether it's private or not. I generally find it's easier to determine what isn't private, why it may already be public. If you learned about it from a public record, it is a public fact, even if it's not widely known. All right. Again, we want to place reliance in our public records. So truthful information that has lawfully been obtained cannot be published. This does not mean you have license to engage in fraud. We'll be covering in 2 months the issues of news gathering, but let me just put something out there right now. You do not have the right to go into a courthouse, say you are somebody you are not, get access to public records. Okay? Even if they're true, you would find yourself in a bad situation. But if, say, a court clerk messes up and hands you something, wasn't your fault, you saw a fact in there, it wasn't otherwise known, but you got it from a public record, that is not the disclosure of a private fact. Something that's already public can't be private. If you are sued or you're threatened with a lawsuit, and you can produce 4 other people that already knew that fact before you ever wrote it, you should be able to consider it public. I'm not saying 4 is the hard and fast number, but if it's something that's already generally known before your story, it's public information. If you saw it in a public place, no matter how embarrassing that might be, yes, you got that picture of the celebrity coming out of their limousine while they're not wearing underwear. You know what? Extremely highly offensive private fact to be seen on the front page of a newspaper or the egotastic website or, Perez Hilton or whatever site there is. but it's also something that happened in public and doesn't give rise to liability. Finally, this is your last-ditch effort at showing something's public, but if the person you're speaking about, writing about, photographing is a public figure, again, the concept that their privacy rights might diminish might get you out of any trouble. So what is a highly offensive private fact? Well, here is my way of describing it. We'll go into some examples, but to me it's more than something that's just private. We're talking about something that people would go out of their way to keep private. Something that I would actively seek to cover up. Again, not something I would not want out there. There's plenty about me that I don't want the public to know. There are also things that I have gone, to lengths to make sure y'all don't know about me. A non-exhaustive list of things that make sense are these: mental and emotional conditions, physical health and medical records. I don't think anybody's going to quibble with anything on this list. These are things that in most states would almost per se be considered highly offensive. But again, it's not an exhaustive list. Finally, we get to the last issue, whether the private fact might be newsworthy in some way, and therefore, even if highly offensive and even if otherwise private, might mean that it should be published. You have to look at the social value of the facts. You have to look at the depth of intrusion. But more importantly, the key question here is, when you printed a private fact about somebody, a highly offensive private fact, was it thrown in a gratuitous manner, or does it bear a reasonable relation to the story you were trying to tell? That's the key question there. That's the easiest way I can define it, and that quote would define it. The line is to be drawn when publicity ceases to be about the giving information and it becomes morbid and sensational. That's the only reason you put it forward. That's where you lose your newsworthiness defense, even as a member of the news media. So, if we don't have any more questions, I hope I've scared you.
Thank you, Kevin. That was terrific.
Thanks.
Actually, I wanted to go back for a minute and revisit some of the conversation around social media.
Mm-hmm.
And we've addressed a lot of issues, and I just want to, because it's so pervasive and so many people are using it now, can you talk about how much control my boss, if I work for a newspaper, how much control does my boss have over what I tweet or put on my Facebook page?
Well, this is relevant to defamation in that, obviously, your boss will be sued for defamation if you're sued for defamation in a tweet. And when we know through the events of this past weekend, when unconfirmed tweets tweets using unconfirmed sources about the death of Joe Paterno, were put out there and were completely false. I mean, in the end, there was really no defamation or other legal violation here. But it shows, obviously, it's another reminder that things do move quickly, things can be wrong, and in other situations they could cause liability. So you have a situation where, as reporters, you're all being asked to tweet, you're all being asked to have, prolific Facebook feeds, you're engaging with listeners, you're wanting them to follow you, you're doing 3 things at a time. Bad things could happen. And yet at the same time, of course, your boss is saying to you, we need to have an image, we need to have standards, we need to have, some sort of control over this. But do more. There's a couple things. Number one is, if it's clearly a business-related account, one that would probably be owned by your boss, they can tell you just about anything with regard to what you can and cannot post in there. Right. That's a given. The bigger issue comes in when you're sort of a public figure in your own right because, you're well known as the State House reporter in Richmond, Virginia, or the Hill reporter covering defense issues on Capitol Hill. But you have your personal account. And maybe it's not about work. Maybe you've tweeted something where your boss doesn't really like what you said. You've had a bad day, you go home, you blow off steam, and it reflects directly poorly on the company. Maybe it reflects poorly on your competitor. Maybe it does reflect poorly just in a general image, way. You've made yourself look like a fool, and by implication, your boss comes off kind of frustrated. Well, according to the National Labor Relations Board, you do not give up all your protections simply by tweeting. Your boss does have the right to discipline you, even fire you for things you've tweeted from a personal account. They do not have that right when your tweets or your Facebook postings are concerted, protected activities. That means they are about the terms of your employment, bettering those terms of employment, and they are intended to band together with other workers to affect change. So idly blowing off steam by complaining about your boss could still get you in trouble. But saying, we're being overworked and underpaid, who's with me, who's with me in trying to change our conditions, that is actually protected, even if it reflects poorly on the company. Okay? Posting pictures of yourself at a trade union rally, if you're if you're going to a journalist guild protest of some kind, a newspaper guild protest, and you're wearing your credentials, or you're wearing a shirt that reflects, or a hat that says Washington Post, or whatever else on it, your boss can't say to you, you're fired for that because it puts our company in a bad light. That is generally what falls into protected concerted activities. And if it has the undesirable effect of making the company look bad, well, so be it. It's protected under the National Labor Relations Act.
Another participant has a social media related question, which is, she says, a law protects a publication when a person defames someone on its website. Would this law protect a publication if someone puts a defamatory statement on a social media site as well?
Let's be clear about one thing, and sometimes people do get tripped up. That law I think we're referring to here, Section 230 of the Communications Decency Act, protects the middleman. It does not protect you when you post to, say, in the comments section of a newspaper. It protects the newspaper from the comments, from liability at the hands of the comments posted by third parties. So if you're saying posting to social media, if you make a defamatory statement on someone else's wall, yeah, you could get in trouble. That person wouldn't. Facebook wouldn't. If you defame someone via a tweet, you can get in trouble. Twitter won't get in trouble, though. That's how that law works.
Okay. And we have another question relating to a different topic. Wendy asks, if a police report shows the name of a shooting victim who is a minor, can the family of the victim claim a right to privacy to keep the victim's name out of the news?
Well, you've probably seen in many publications, including, I know, the Washington Post, and Bob can attest, since I think he covered this beat for a long time, that the Post regularly puts in their stories, the Washington Post, to not identify, minor sexual assault victims of sexual crimes. I'm not sure, I don't recall right off the top of my head what the rule is for minor defendants or victims. But the reason they do that is to say it's our policy. Legally, you have the right to do it if you have lawfully obtained information from a public record. Now, a state's law, they may very well say this information is not supposed to be given to the press. This information is not supposed to be published. But generally, that was sort of the old style version. The second one was the old style version of the law. It's not supposed to be published. There may be rules saying this information is not to be given out by a court clerk, that the courts have the ability to close proceedings, to seal records when a minor sexual assault victim is involved, to avoid the naming and perhaps embarrassment of that person or their family, or the invasion of privacy. But if you lawfully, somehow that information falls into your lap, you do have the right to publish it. Yeah. Many publications, again, just simply say, we still won't.
One last question. We used to worry in the newsroom about slap suits.
No. Yeah.
How does that fit into what we're talking about?
Well, yeah, it's a great question because, again, it's been in the news for the Daniel Snyder lawsuit. Slap suits, the term slap refers to strategic lawsuit against public participation. Generally, these are defamation lawsuits, but they can be anything. They can be copyright infringement, allegations of unfair trade practice, even breach of contract. And they're brought simply to make things difficult for someone who's spoken out on a matter of public concern. And so an anti-slap lawsuit is something which accelerates the defense in a frivolous type situation where it's clear that the only reason you're being sued is to shut you up. You may have the right, if this statute exists in your state, to not only accelerate the proceedings, put the onus back on the plaintiff to continue those proceedings, but perhaps even get your costs paid for, which generally isn't the case. Generally is not the case in the United States that a losing defendant can get their costs paid for as a matter of right. These laws do sometimes make that as a matter of right, and even give you perhaps triple damages. The problem is they don't exist in every state. They don't exist in a great form in every state. For instance, Maryland has this law, but some people think the state would actually be better off, or speakers in the state would be better off if the law didn't exist. That's why there's a movement right now to create a federal anti-SLAPP law that would allow defendants in states that don't have this protection to take advantage of an anti-SLAPP statute, and allow those in states that maybe their law just isn't good enough to take advantage. In full disclosure, I'm a member of the board of directors of a group called the Public Participation Project that is trying to lobby this effort. So I want to put that out there, that I have a vested interest in it. But as a media attorney generally, of course, I like them, because litigation, right or wrong, litigation is expensive. I was just telling Bob that my wife is an attorney, and she's involved in a lawsuit where they're the plaintiffs. It's not frivolous. They're at trial right now. And I'd estimate that, millions of dollars have been spent, not just in legal fees, but in flying in, prepping witnesses, putting people up in hotels for weeks at a time during this trial. Litigation is just a reminder, even a shocking reminder for someone like me, an attorney, just how expensive this can be.
We have just a few minutes left, but we have an intriguing question again from our participant in Mexico, who says they were able to get video of someone, an 18-year-old, getting drunk with her friends in a bar in Mexico, but they fed the video to a San Diego TV station.
Oh boy.
The question is whether they are liable if she complains.
Did it happen in public?
Apparently
if I
so,
were
in a
that station, I would feel, especially if it were it sounds like this is probably newsworthy. I mean, I'm guessing that the story might have something to do with a lot of people, a lot of Americans who are under 21 but over 18 going to Mexico so they can drink excessively, the dangers that arise. I think, to me, that's something that you would feel good about running, because it happened in public. It's not exactly a private fact for that reason. It's not at all. I'm not even sure it would be highly offensive. She certainly didn't take steps to cover this up. And it's a very newsworthy story. Not as long as it's not presented in a completely gratuitous manner, I think it's got some newsworthiness to it. So I would actually feel pretty good about doing that in the right way. I would always say that I'm not giving legal advice through these webinars. I would want to see it personally. I do recommend that you consult with your attorneys. I always recommend that you consult with your attorneys. If not your attorneys, certainly your editor, who can make the decision whether it's worthwhile to bring the attorneys in. And the attorneys may make the decision that it's worthwhile to at least contact your insurance company if something goes wrong. But the earlier you can get ahead of problems, the better you are. And that often means at least consulting with your editor, if not your attorney, if you're lucky enough to have one sort of on a regular consultation basis, someone who can do things on the cheap. There are plenty of free services I can tell you exist, that, like the Reporters Committee for Freedom of the Press, the Citizen Media Law Project out of Harvard University Law School. A lot of different possibilities for student journalists. You can always contact the Student Press Law Center, and they can give you assistance. They can refer you to attorneys. But I think all of these are things that I think people shy away from because it's expensive. I get that. But the upfront cost maybe drops in a bucket compared to what I just told you could end up being millions of dollars. I mean, even if you have insurance, the insurance, I talked to somebody who was sued, and they settled on the courthouse steps, didn't even get to trial. Their insurance premium went from $4,000 to $80,000 as a result of that actual lawsuit and the settlement that was paid.
Well,
Something to think about. Yeah.
Now you
Real
really
money.
scared me.
Real money.
Kevin, thank you so much.
You're welcome.
I want to thank everyone who's been able to participate with us today, and particularly Kevin Goldberg of Fletcher, Hildreth. I want to remind you to join us at 12:30 on February 28th for the second installment in the Legal Issues series. We're going to be talking on that day about copyright for the web. And in the meantime, check out our other free programs for journalists at our website, www.nationalpress.org. Thanks for joining us.